Hello, I'm attorney Robert A. Broadie of Carolina Legal Solutions, and I want to again thank you for tuning in to another episode of Testimonial Tuesdays. Today, our question comes from Jeff, and Jeff asks a question as it pertains to his Miranda rights. And his question is as follows. I wasn't given Miranda rights and not permitted to speak to attorney. What does this mean in my defense? Jeff goes on to say that I was arrested for DWI, and although I repeatedly requested to speak to one, the police would not let me contact an attorney. I was also never read my Miranda rights during the process. Will this have an impact on my litigation? And I have a professional career, and I have never had any prior encounters with the law. Well, Jeff, I first want to thank you for your question, and it is a very, very good question. It's a question that I hear a lot, particularly from criminal defendants when they come into my office. There's a misconception, a common misconception, that when law enforcement fails to read a person their Miranda rights, that is somewhat of a get-out-of-jail-free card. Well, essentially, Miranda comes from Arizona v. Miranda, is a segment of the law that requires law enforcement to read certain rights to potential criminal suspects, but that right only attaches to statements that are made to law enforcement while that suspect is in custody. So there must be a custodial taking and an interrogation. Now, if officers refuse or fail to do that, that doesn't necessarily mean that your case is going to be dismissed or that is a substantial violation of the law that renders your case moot. But what it does mean is that if there's any statements made by a defendant or potential defendant while in custody and while being interrogated in custody, such a statement cannot be used against that person in a court of law. So what that essentially means is that if I was arrested or taken into custody and questioned by law enforcement and taken certain statements were taken from me, and then I was subsequently arrested, well, law enforcement, if they did not read me my Miranda rights, may be permitted or prohibited from using those statements against me in a later trial. So simply because an officer fails to or refuses to read a person their Miranda rights only means that any statements taken during that custodial interrogation can be prohibited from being used in a criminal prosecution. Now, that is what Miranda does for an individual who has not read their Miranda rights. However, Jeff, you may have other issues as it relates to denial of access to individuals being able to witness certain stages of the process of your DWI arrest. That is another question for another day, and we'll be glad to answer that question on a later topic. But Jeff, I would highly recommend that you speak with an attorney because there are some other issues that not pertaining to your specific question that may give a rise to some defenses and some potential challenges to the process under which you were arrested for this DWI. Particularly, you are allowed access to friends and family members to witness any breathalyzer or testing that is done pursuant to your arrest for DWI. So, Jeff, we do thank you for submitting that question. I hope my answers answered your question as it pertains to the Miranda rights. And we want to again thank you all for tuning in to another episode of Testimonial Tuesdays. We want to encourage you all to submit your questions on our Facebook page or on our website at www.carolinalegalsolutions.com. If there's anything that we can do for you, feel free to call us at 336-885-1529. That's 336-885-1LAW.